next case to come before the court is State versus Jordan. And the state, the appellee has waived, so you'll just present your 15 minutes.
Thank you.
Thank you. And thank you for accommodating the court to the session.
Happy to do so. Morning. May it please the court, I am Alan Medvick. I represent the appellant Robert Jordan in this matter. Mr. Jordan has one issue on appeal. This is an appeal from a plea, and the only issue before the court is whether that plea was knowingly, voluntarily, and intelligently made. Mr. Jordan argued, we would argue that the plea was not properly taken, as he was not informed of his of the fact that he would be waiving the right to appeal the adverse rulings in his pretrial motion. That while the court did notify him clearly that he would be giving up his appellate right to a trial regarding any trial verdict, the law's pretty clear. He has to be notified that he's giving up all non-jurisdictional claims prior to his plea, and there was at least one adverse ruling on pretrial motion that he was not notified of. Obviously, he could have, had he been notified, discussions regarding a no contest plea or whether he wanted to proceed to trial to preserve that right would have been available to him.
It seems to me that the argument you're making, though, sounds like it's more something that his attorney should have been advising him of, not a requirement of the court.
And I would dispute that in that the right to appeal is has been held to be a right that has to be notified to the client by the court as part of the plea colloquy, and
the court did so.
The court is very specific in its language, stating that it was only regarding a trial verdict, and I would state that it's the court's job at that point to make sure that I understand that there are conversations between all trial attorneys and their clients, but it's the court's job in taking the plea, and this has been established well over time regarding the number of things that I understand that a trial judge has to notify a criminal defendant on, but those are hard and fast, and I think that there's a distinction here, in particular because there were pre-trial motions. It's not there's a distinct right there that can be preserved by other means, and that I think that the judge has a responsibility, constitutional responsibility under Ohio law to make clear to the client, to the criminal defendant in taking the plea. And I don't have a lot. I mean, it's obviously it's one issue. I would point out that the appellee's reply is non-responsive and does not address the issue. His statement that I am arguing that the court did not notify him his right of appeal, and we're here on appeal now, is a facile way of stating the case. I think it's clear that the issue that I've raised, if I had brought a challenge to that pretrial motion, the response of this court would have been that was waived as part of the plea. Other than that, I don't think I have much more to add beyond the briefing.
I have a question.
Yes.
I just wanted to make sure that I was clear on the nature of your argument. Are you arguing that the court's failure to advise your client of his ability to appeal pretrial issues violates the statute, an Ohio statute, or the U.S. Constitution?
And obviously, I would argue that that's that the right of appeal is a constitutional right.
Well, but again, we're talking about the right of appeal having been, he was advised.
And
you're saying that.
And I'm arguing that under I believe it's a constitutional issue that he was improperly advised by the court, and that he was not fully advised of his rights to appeal. Thank you.
Thank you.
Thank you very much. The court will take the matter under advisement and issue a written opinion that will be sent to you
I appreciate your time.
and put on the website. Thank you.